Makes please. Hello. I have filed an affidavit, but I'm not pressing that one in view of order dated 3/4/24 and 8/5/24 because resolution number 4 and 5 was appeared. My affidavit was that to accept the notice that was served on 3 and 4 at Delhi, Mother. That was the affidavit. So that has become meaningless, and I'm not pressing that affidavit, Mother. That is one part, Mother. First part.
3 and 4 had already appeared.
They have already appeared, Mother. There is, your lordship may kindly see order date 3/4/24 and 8/5/24. They have already 3 and 4. They have already appeared.
Yes.
They have appeared.
So what about 4 and 5?
Yeah.
4 and 5?
4 and 5. Yeah, 4 and 5.
Achha.
So since they have appeared, my lord, my affidavit which was filed, my lord, just 2 days back, my lord, I think, yes, 2 days back, that has become many days, my lord, is not
regarding the service of notice only.
Yes.
That
So-
affidavit was regarding the service of notice.
Exactly, that was
Then
that
they
was-
violated
So
it.
I'm not pressing that affidavit. That is one part, my lord. The other part, my lord, that response number 1 to 3, they have filed affidavit in opposition in this case, my lord.
1, 2, and 3.
1 to 3.
Hmm.
Now, I need to file a reply that I am praying for a month's time, my lord. Let the matter come up on 1st of August. If there is no difficulty.
I have no problem with that one. 1st of August is perfectly all right. But there appears to be some error. This matter has been brought to my notice very recently. Apparently, there's a statutory provision under challenge and notice was issued to the Advocate General. It appears that the Commission has filed an affidavit on behalf of 1, 2, and 3, which is perhaps not correct. We will have to, on behalf of the state also, we'll have to file an affidavit.
Oh.
So your lordship will grant us the liberty. In the meantime, let it be fixed on 1st of August. In the meantime, whatever affidavits are required, we'll file.
For 1, 2, and 3, already Commissioner has filed.
They have already submitted.
It could not have been filed on behalf of 1 and 2.
Okay. Yes.
There appears to be some mistake. So your lordship will grant us the liberty. If necessary, we'll file for the affidavits.
Further affidavit.
And in item 2, we have not filed the affidavit yet. So we may be given some time to file an affidavit.
So, your lordship may, first of all, your lordship may order that the affidavit we are not pressing, my lord. That is one. The second, my lord, we may be granted time to file it. That's.
Let's say that I am seeking for seeking in item number 1. If so, by the matter respondent number is on the last of the matter I appear paper of the respondent number 4 and 5. The if so, matter will file a affidavit.
You also filed. Pardon, Mr.
Decadas,
Yes.
assisted by.
Hard Mr. Brigade, which is senior advocate.
Number 3,
Assisted by C. Eddie, MSc Eddie, and also had Mr. I. Chaudhary, the learned senior learned additional learned advocate general Arunachal Pradesh, appearing on behalf of 1, 2, and 3. Assisted by, you are assisted by someone, assisted by Mr. S. Tokil, the learned senior advocate, Arunachal Pradesh, and also had Mr. the learned counsel appearing on learned standing counsel appearing on behalf of respondent number 4 and 5. It is submitted by Mr. Das, that the senior advocate, that he earlier filed an affidavit on in regards to service of notice on respondent number 3 and 4. But he doesn't want to press this him as the respondent number 3 and 4 had already appeared in connection with this case. 4 and 5. The 4 and 5.
4 and 5.
4 and 5. Sorry. Had already appeared. However, he submitted that he needs some more time to file their affidavit in reply against the affidavit opposition filed by the respondent number 1, 2, and 3. Mr. I. Chaudhary, the advocate learned advocate general, also submitted that though the advocate general was the submitted that inadvertently, the commissioner has already filed, the deputy commissioner has already filed the.
Commission.
Sorry, commissioner. Commission has already filed the affidavit of position on behalf of respondent number 1, 2, and 3. And as the state and inadvertently, he did not inadvertently, however, he wants to file the affidavit in opposition separately for the respondent number 1 and 2. Mr. M. Kato also submitted in this regard that he is representing respondent number 4 and 5. And he also needs some more time to file the affidavit in opposition. Next, part, considering the submission made by the Learning Council for both sides. List the matter after 4 weeks you need.
4
or
weeks time. Let
after
the
4 weeks?
4 weeks back. Let the matter come up on 1st of August. 1st of August.
First week of August.
No, 1st of August.
1st of August.
1st of August.
The matter will be listed on 1st of August. 1st of August is a working day, na?
If it is a working day,
So and so, enabling both the parties to file their affidavit in opposition as well as the affidavit in written. List accordingly. It is 1 and 2, 2 for 2 for your.
For in two, no affidavit has been filed so far. So your lordship will grant us some time to file an affidavit on behalf of the state.
in that, in two, we have received an affidavit in opposition. That's 1 to 3. 1, 2, and 3.
In that case, the same order may be passed.
1, 2,
1,
and
2,
3.
and 3.
And we'll file
Same order as in item number 1 will do in that case.
Same
if
order,
necessary, we'll-
item number 1. Here also 5 numbers of.
if necessary, if he intends to file an additional affidavit, we'll file a reply.
Yes, sir, that is,
Uh,
because it was submitted by him that it was inadvertently filed, because advocate
Yeah.
general is there. So
Right.
that's right. Okay, same order. will be
Same
for
order.
1 and 2. Both the
Fixed on
matters will
1st
be
of
fixed on 1st of August. What is the IA about?
No,
What
think-
IA is there? Why?
I think that is the affidavit that we have filed. I think,
Acha.
I don't know.
Okay,
Did you
let me
check it
see.
out?
Okay.
Madam,
Right.
Madam,
Unit
I-
3J is not party.
You?
Item number 2. Unit 3J is only
Okay.
party, item number 1.
You are not the party on item number 1.
no.
So 1, 2, and 3 are on the party.
Because same issue, I think we have not made party, but same issue, I think.
So why don't you make,
If you want,
why if they want, why you have not made party? If their presence is required, if their affidavit will be required because they are, most probably they have been included as a party, I think, because
item number 2, 3, 4, and 5 is not a party there.
Is for the stay of the provisions of that act. This IA, you have filed for stay of the provisions
you
of
check
act,
this one.
Yes.
suspension of operation of the
But-
provision of.
But that perhaps has become infructuous in view of the order passed in item number 1. Item number 1, interim order was specifically rejected.
Which,
So therefore, this IA perhaps has become infructuous.
so you are not pressing.
Not pressing at this stage, but we'll let it come up because I was not on this. Madam, let it come up on 1st of August.
This IA also,
I also,
but that's one we have already.
yes, madam. If we have to address anything on that, madam, we'll address on 1st.
Nothing is there if your prayer has been rejected, it has already been rejected. For stay of the operation of the act.
That in any case,
Yeah, that part is also there. Because my interim prayer was that, my lord, actually, what was that, my lord? We have silenced an act that was passed by the state government, my lord. We say that act, because all acts are to be passed under 7th schedule. It has to be in the union list, then state list and all. This, they have education is not in a state list. That was deleted in 84, my lord. That it has come to concurrent list. Now, our challenge is that, my lord, that this act, which it was passed, my lord, that has to be in conformity with the entry. You cannot surpass the central law because in central that UGC Act is already there. We will argue that point, madam. That is a point, madam. Let the IAB defer, madam, defer. See, because that matter, madam, that matter was deferred only because that notice was issued to the Advocate General for his presence that it could be heard. Since earlier, madam, that because of some difficulty, as he was not here, madam, that matter was deferred. Let it come, madam, afterwards. Let it come afterwards. We'll try to decide. Obliged, madam.
This is for suspension of sentence. This I had made this application on the basis of medical report submitted by the Board of Doctors.
Lordship, Lordship, we have not received any instruction, Lordship. We have furnished this necessary order, Lordship, last order, but till now we have not been received any instruction, Lordship. Lordship. We have taken a step, Lordship. We have furnished the order, Lordship, to the jail authority, but we have not received any instruction.
His condition is going worse day by day. So even I had filed a criminal writ also in this case.
Lordship, that's why, Lordship, we have seek the information, Lordship. We have furnished this order also, Lordship, but we have not received, Lordship. Lordship.
In that case, I will pray for the interim because his health is deteriorating day by day.
At the time, the operation has taken any proper steps for his the independence or even for the operation.
Next week. Okay, next week. No, I have not. I have to be there here because his condition is worst. So I will have to be here on the next week.
Lordship, Tuesday, Lordship.
Tuesday. Okay,
Lordship.
11. DK David. Eleven. Complete. Even item number 4 may be listed on 11. The appeal. This is paper book is ready. I had received day before yesterday. Yes, otherwise ready for you. On the 11, let it be fixed for 11. Because I had received day before yesterday only. I need to prepare some.
Your Honor, item number 4, my lord, I am for the respondent number 2, 3, and 4. On Tuesday, I have some difficulties, Your Honor. So it may be fixed in some other day. Yeah. Thursday,
Thursday will be fine. So Thursday will be.
Instead of second. I mean, the Tuesday and that other one is Thursday, or both the matters can be.
What the matters to be listed? Because for me, it will be convenient. Thursday, date?
Thursday, the
13th, okay, obviously. Okay.
Right, Lucy.
May it please your lordship. Your lordship, this IA has been filed for condemnation of delay of 121 days in filing criminal appeal number 51 of 2024, Your Honor. Twenty-one days. Yes, Your Honor. Against the impugned judgment and order dated 4/12/2023 in Pasigat session POXO case number 11 of 2021 under section 376/506 IPC read with section 6 of POXO Act, wherein the accused was convicted and sentenced to imprisonment.
Matter is regarding transfer, madam. Today, if time permits, madam. Because, my lord, today, why I'm mentioning today? Because today is the last day. The opposite party will be released from their place of transfer, madam, posting, madam. So by 2 o'clock, public.
And item number 22, my lord. I've taken the consent of the other party, but the amount is also out of station. Therefore, this matter may be taken after 2 weeks. How is the respondent under position? Letter of action is also solved.
You are appealing for Mr. Mark? Yes. Yes.
Nanda.
Madam, and for the junior opinion, I did. I mentioned item number, madam, 23, madam.
You are 22 or 23?
22, madam, I mentioned first, madam, 23 is also madam. Item number 23, madam, I have from consulting.
Submitted by the MSK Nanda, the NP's counsel, Mr. Esma, who is out of station. According with bid for an adjournment, prayer errand. List the matter accordingly. You want how many weeks in 20?
2 weeks.
Okay, 2 weeks. And item 23, what are that?
Madam, item number 23, Madam, as I have taken
It was
consent
a
from.
fixed case in fact.
Madam, fixed case, Madam, in fact, Madam, the records instruction has not been received by the, Madam, the state, the council and the respondent council, Madam. And the last occasions, Madam, they have, wherever sought for taking instructions from the, Madam, department, Madam, they are informing. So far, they have not received, Madam, any instructions from the, Madam, the concerned department, from the office of the deputy commissioner. Madam.
Just prayer for Miss API, na,
Correct.
for instructions. Now,
Correct.
what you're praying for?
Now,
You're
Malad,
also seeking some instructions for what?
Malad, the instruction, Malad is informed by the counsel for the Malad district respondent. She has not received Malad so far, Malad, the instructions from the concerned department. So therefore, Malad, and my name is also not shown. Because of that reason, Malad, I could not bring my, Malad, brief.
So otherwise, you are representing 123 only.
Malad, I am for the, Union of India, man.
One.
Not one, Malad.
Union of India is? I can,
23, Malad.
no. Yes, in 23, you are, Union of India is 7, I think.
Malad. And Malad, my name may be shown in the cause list.
But Mukpatin is absent today.
Malad. I've taken
Counsel
consent
for
from the other
the-
party, Malad. Senior counsel and party, Malad.
Had Mr. M. Patel learned it. He is here for the respondent number 7, and also had MSG 80 learned senior government advocate appearing for respondent number 4 and 5. It is submitted by her that as per the order dated 29/5/2024, the state respondent was supposed to collect the instructions from the authority concerned, but till date, they have not received the instructions. And for you have an instruction or you are going to file the additional affidavit?
No, Malad, in fact, we have already filed affidavit, Malad.
Your affidavit has already. In this context, Mr. Kato submitted that they have already filed their affidavit in opposition for the respondent number 7. So why you need an adjournment today?
Malad.
Why you need an adjournment?
Malad, that's because firstly, Malad, I have not brief is with not with me, Malad. Secondly, Malad, no instruction has been received from the deputy commissioner, Malad.
However, with the consent of the other side, Mr. Katos prayed for an adjournment, stating that he has not received the instructions from the deputy commissioner, and he received it briefed very recently and needs some more time for his preparation. Further, he submitted that his name has not been reflected in the call list, and accordingly raised, he have directed to reflect the name of Mr. Kato, who is appearing for the respondent number 7 as respondent number 7. Mr. Kato, the learned DHA, appearing on behalf of respondent number 7. Raised, he will do the needful accordingly. Raised, no matter how many weeks you need.
Malad, after 2 weeks.
Raised accordingly after 2 weeks.
Deputy.
Lordship, I beg to mention item number 21 on behalf of T. Tagum, standing counsel for health. I have taken
Now,
consent.
this is the case of 2015, in fact. Yes.
Lordship, though this is a fixed matter, but due to personal difficulty of the standing counsel, he could not able to complete.
For whom you are preparing?
On behalf of T. Tagum, standing counsel for health.
Your engaged counsel, Mr. Esmao, is also not present.
No, as for, I'm appearing this case also.
You're personally appearing
Appearing
this case. Okay. Heard MSK Nada, the learned counsel for the petition, and also heard Mr.
Arpuyu.
R. Poem, the appearing on behalf of Mr. T. Tagum, a standing counsel of health department, and he submitted that due to his personal difficulty, the standing counsel of the health department is not in a position to argue the matter today. Accordingly, with the consent of the other side, paid for an adjournment. Now, this was fixed because it is a case of 2015. So we are going to again fix the date, and in that case, definitely will go for the argument. So when you need the witness? When you will be available?
Where is the problem?
17th.
17th, let it be on 18th. Fix on 18/6/2024. Directing both the parties to proceed with the hearing on the next day without waiver. 18/6.
Oh, bless you.
May Lordship, I beg to mention item number 11 on behalf of R. Saikia, Standing Counsel, NIT, Lordship. here we have to file affidavit in opposition, a reply, Lordship. The matter may be
You have already filed or you need time?
need time,
Affidavit, you need time.
need time, Lordship. I have taken the consent from the other side.
With the consent of the other side, the learned counsel for the respondent appearing on behalf of Mr. R. Seke, the standing counsel NIST, paid for an adjournment, stating that they need some more time to file their affidavit in opposition. Prayer allowed, please the matter accordingly. You all need how many weeks?
2 weeks, Lordship.
Please accordingly up to 2.
Highly honored.
Lordship, I would like to withdraw item number 10, Lordship.
Item number 10.
10, yeah.
Why? What is the?
Lordship, it is regarding only the representation issue, Lordship. Just the approach electrical division petitioner has given one representation. So representation was pending before the EE. So the client is settled
As
in
per
outside.
instruction.
Yes.
What
Client
is
is
the good name?
T Topu.
For Mr. T. Tapu, the learned counsel for the petition. And it is submitted as per instructions of his client. And he wants to withdraw the present petition, which was only for present petition. Liberty you don't need, you
No.
just you want to withdraw it.
Yes.
Upon the considering the prayer made by the so and so, let the matter be, and the matter is disposed of on withdrawal. Oh,
May I, Your Lordship? I beg to mention item number 16. Your Lordship, I am appearing on behalf of AK Singh. Due to some personal difficulty, he is not able to present. And I have taken a consent from the other party also. Your Lordship, the matter may be listed after 2 weeks.
after
2 weeks.
you are Mr.
T. Nima.
and Mr. T. Lima appearing on behalf of Mr. A.K. Singh, the learned and guest counsel for the petitioner. And with the consent of the other side, he paid for an adjournment stating that the and guest counsel, Mr. Singh, is not in a position to attend the court today due to his personal difficulties. List accordingly after 2 weeks.
Give your much.
Lordship, I would like to make item number 24, Lordship, for the supplementary hearing. It will be listed on Monday, Lordship. I have taken consent from both the parties. At the amicus, Mr. Boje sir is not there today, not present today.
Pardon?
It's amicus curie, Mr. M. Boje sir is not present today, so it may be take on Monday, Lordship, to be listed on Monday again.
With the consent of the other side, the learned Christian PP, MS L. Haggis, paid for an adjournment. This matter stating that Mr. M. Boje, the MFS curie appointed on behalf of the respondent number 2 is not in a position to argue the matter today. This is Monday.
Lordship, Monday.
Monday. This Monday is with which time? Then.
Obliged, Lordship.
May I, Lordship. Lordship, I beg to mention item number 12. I'm appearing on behalf of A. Tatak. I'm appearing on behalf of Mr. A. Tatak. He's out of station. So, Lordship.
Taken consent of the other side?
Yes, Lordship.
Same order, could you?
Yes, Lordship, this matter may be after 1 week.
After?
1 week.
List accordingly after.
Plus.
May I please, Your Lordship? Your Lordship, I beg to mention item number 7, Your Lordship. This item may be taken out after 2 weeks, Your Lordship.
Why?
Your Lordship, today we are not ready, Your Lordship. I'm appearing on appearing for respondent number 1 to 5, Your Lordship.
1 to 5. Yes. You are for the petitioner.
No.
With the consent of the other side. The learned, you are government advocate. No?
Yes, Your Lordship.
Government advocate, MS Swenso, paid for appearing on behalf of state respondent number 1 to 5. Paid for an adjournment, stating that she is not in a position to argue the matter today. And you used 2 weeks.
Yes, Your Lordship, after 2
List
weeks.
accordingly after 2 weeks.
Obliged, Your Lordship.
Your Lordship, I beg to mention item number 20. I'm appearing on behalf of L. Kurdu, Your Lordship. Here we have to file a rejoinder. So I maybe allow some more time to file the rejoinder, and I have taken the
Have you
consent.
informed the other side?
Yes, Your Lordship.
Your MS?
Tirimi.
Edimi, the council appearing on behalf of Mr. L. Kundu, the learned and his counsel. And for the petitioner and with the consent of the other side, separate some more time to file their affidavit in reply. Post of list accordingly after 2 weeks.
After 4 weeks, Your Lordship.
List accordingly after 4 weeks, enabling the petitioner to file their affidavit in reply.
Obliged. There is interim, Your Lordship. Interim is there, Your Lordship.
Interim will continue till next date of list.
Item number 1.
Your Lordship, this is a writ petitions. This is second round of writ petition which I have filed for initiation of departmental proceedings against the government servant for violations of Rule 21 of CCS Conduct Rule for entering into a marriage with a person having a spouse living. So I need, and I'm challenging.
Amended.
Yes, amended
is
because
filed.
yes, I have filed.
So who are to implement this part in
The
number
pa-
5?
Five.
Inspector.
Inspector
Chapang.
Chapang, yeah.
But this is the person against whom. most
Yes,
of the
against
allegation has been
whom,
brought.
yes.
The question is that he is not named. Is there any issue? Because he is stated to be the husband of the petitioner.
No, he is the government servant against whom I have filed a complaint. Husband, not against husband, against this respondent number 5, who had entered into marriage with a person.
That's what I'm saying. Against the respondent number 5, the allegation was, or your prayer was before that
Yes.
for initiating any inquiry or not.
Yes.
So my question is that why again the respondent number 5 is made as a party Inspector Chapang Long. His name is, he is not named. I mean, the respondent is, he is not made party by his name. That's what I'm saying.
Because in all the correspondence, whatever between the department, it is written Inspector Chapang. So I had, because even in that,
But that is his designation, I think.
yes, that is his designation. He is inspector.
Then he is inspector.
Yes, he is
He is she.
C.
Acha. But her name is not there, that's why. Whatever he or she, whatever, but he or she is not named as a party. I mean, Inspector Chapang is there, but her name is not there.
Chapang Luang is her name.
Huh?
Chapang Luang is her name.
District ne ki? Is it a district? Chapang?
No, that is the name of the, my lord, respondent number 5, my lord.
Oh, it is her name?
Yes, my lord. Your lordship will find difficulties.
I thought it is some district. or
No,
state
this
or
is
not.
Changlang is there. No.
Inspector Chapang Luang.
Is the
Name of it.
Oh, so then it's okay. Yes, then
Notice is required to be issued in this matter.
the private respondent is there. No?
Yes, private. So I will take steps on her.
Then who is the petitioner? MS Sujan?
She is the first wife.
Oh. So you are not filing any case against your husband?
Husband, no, I am not fine.
Why?
The husband, because he is
He
that,
he married the lady.
but he is not covered under CCS rule.
Huh?
He is not covered under CCS rule. This lady is covered under CCS rule.
Oh.
He's a public leader.
He is a public leader.
Had Mr. Swenso, the learned counsel for a petition, as in pursuant to order dated 29/5/2024. The petitioner, the respondent number 5 is made party in this case. And she has been newly implemented accordingly. Also heard. You are appealing for one? You are appealing-
Yes, ma'am.
1 to 4 years.
1 to 4. Also heard MS, you are MS?
P pound, Your Lordship.
P Pound, the learned comment advocate, appearing on behalf of respondent number 1, 2, 3, and 4. Post of issue notice to respondent number 5 to register AC and as usual process. Released accordingly after 4 weeks.
Can a date be fixed on 26th of June?
26th of June.
June.
Will it possibly?
Yes, it's in Itanagar only.
26th of June,
26th.
you need. Okay, listed on 26th of June.
Requisite copy.
I will supply.
The petition is also directed to furnish the requisite copy of the petition to the respondent, state respondent 1 to 4.
Okay.
Item number 2.
Wait, please. My lord, petitioner is basically aggrieved by the action of the respondent authorities, that is the Bharat Petroleum. In my lord, rejecting the provisional selection of the petitioner as a retail outlet on flimsy grounds that the lease deed, which was registered as required by their clauses, was also notarized by. How does the document being notarized, my lord, makes it invalid? That is my case. My lord knows the Bharat Petroleum, my lord, is a public sector undertaking under the Ministry of Petroleum, and as such, my lord, is a state in terms of Article 12 of the Constitution, and as such is bound by the constitutional provisions and other laws. My lord will kindly have page number 26. This is the advertisement seeking applications from applicants for retail outlets, petrol pumps, all over the state. That included one at Pasighat for the location, my lord, Sivokorong to. Just a moment, my lord. There's location at Pasighat. Sivokorong to. So in terms of this, my lord, this brochure was furnished to all the interested parties at page 28. My lord will kindly have page 28. Now, these are the clauses setting out the eligibility criteria and everything, my lord. Eligibility criteria, your lordship will find at page 31. I will only rely upon the relevant provisions. Page 31, serial number, clause number 4.
Serial number?
4.
Eligibility criteria.
Yes, eligibility criteria for individual applicants. Now, my lord will kindly have Roman small 4 at page 32. Land applicable to all categories. At page 32, man. It says the applicants will be classified into 3 groups as mentioned below based on the land offered or land not offered by them in the application form. Group 1, applicants having suitable piece of land in the advertised location area, either by way of ownership or / long-term lease for a minimum period of 19 years, 11 months as advertised by the OMC. So you either you have own a land or have a leased it from somebody, minimum period of 19 years. Now, your lordship may kindly have page 33. F. In addition to the above, as and when advised by the OMC, provisionally selected candidates under Group 1 should also upload a copy of any one of the following documents to establish ownership of land offered to the dealership. The documents must be executed, registered, issued on or before the date of application. Number 2, my lord, registered lease deed for a minimum period of 19 years and 11 months as advertised by the respective oil company. So it says you must have a registered lease deed. Now, my lord will kindly have page number 108. I applied, my lord, being interested, I applied. This is the communication, my lord. This is dated 16th of December 2023. By this, I was called for the draw of lots. How they do it is that they do a draw of lots. And who, yes, draw of lots. Lottery.
Draw of lots, I see.
Yes. I was asked to come to Hotel Rajdhani Residency, Dispur last gate. And the draw was to be done on 27th of December. When the draw was done, I was declared successful. Page 109. I was declared to be successful. My name came out. Then my lord will kindly have page 110. On 20th of December, I was asked to furnish the following documents on or before 7/1/2024. 110. Yes. After I was selected, provisionally selected. My lord will kindly have
Serial number 6, copy of land documents in support of ownership / lease rights. My lord has seen the brochure.
Hmm.
I am required to furnish a registered lease deed.
Hmm.
Now, my lord, in terms of this, I submit all the documents, including the lease deed. My lord will have the lease deed at page number 123. I am sorry, my lord, these documents should have come earlier, my lord. Sorry. 123. There is no issue with the document. Only thing, this has also been notarized. My lord will see at page 126, it was duly registered also, as required by them. Page 126.
So it was not,
It was notarized also.
this was notarized.
Yes, executive report and notary.
So it was not registered.
It was registered, page 123. Notarized as well as registered. Page 126, my lord will see. It was registered before the sub-registrar East Siang district, Pasighat. It was notarized as well as registered. Hundred and 26 is also seen.
Hmm.
Now, the impugn communication is page 121, annexure 8.
Hmm.
Serial number 3.
Hmm.
However, it is observed that the land documents submitted by you are not valid for considering offered land under Group 1 for reasons as detailed below. Notarized lease deed cannot be considered under Group 1. Now, they have totally forgotten the fact that it was also registered. What is the purpose of my lord having it notarized? It is even more authenticated, my lord. Does not make a document invalid, my lord. My lord has seen the terms and conditions. They say you have to submit the register's list. We have done that. In addition to that, it notarized. Does make it invalid, my lord, this document? In my
So
humble
if
submission,
you have
no.
to register the document, why you go for the notarization of with the ministry?
My lord, we did it, but that does not make the document invalid, my lord. It was duly registered. In any case, my lord, these are not conditions, my lord. This does not make the document invalid. How can you do that, my lord? This has been well settled by the Honorable Supreme Court, my lord. My lord, kindly have 1991, my lord, 3 SCC 273. And no prudent man, my lord, on the basis of this, will reject a bid, my lord. This is not even an essential condition of contract, but even then, my lord, for the since they have done it in this manner, my lord, I am just relying on this. Order is still, my lord. Paragraph 6.
Hmm.
It is true that in submitting a tender accompanied by a check of the Union Bank of India and not the State Bank, clause 6 of the tender notice was not obeyed literally. Here was a case, they said you have to submit a check issued by the State Bank of India. They submitted a check by the Union Bank of India. Similar, not even similar, man. But the question is as to whether the said non-compliance deprived the diesel locomotive works of the authority to accept the bid. As a matter of general proposition, it cannot be held that an authority inviting bids is bound to give effect to every term mentioned in the notice in meticulous detail and not entitled to waive even a technical irregularity of little or no significance. The requirements The requirements in a tender notice can be classified in two categories. Those which lay down the essential conditions of eligibility and others which are merely ancillary or subsidiary with the main object to be achieved by the condition. In the instant case, the authority issuing the tender may be required to enforce them rigidly. In other cases, it must be open to the authority to deviate from and not insist upon strict literal compliance of the condition in appropriate cases. My lord, I ask myself the question. I have notarized it before a notary. Does that make the lease deed invalid? What does they want? or group one, then you have to have a lease deed for the purpose of showing ownership of a land. So where the petrol pump can be established. This lease deed does not become invalid just because you have notarized it. So it's a valid lease deed. So just because I have notarized it, it is a totally arbitrary action on the part of respondent authorities to, my lord, reject my deed. That is my humble submission. And my lord has seen this as not a condition, my lord, that can be termed as essential, my lord. One more judgment, my lord. State, my lord, even in terms of contract, my lord, they will have to act arbitrarily, cannot act arbitrarily. 1991, 1 SCC, my lord, no, Sri Lanka Vidyarthi, my lord, 213.
1991?
1 SCC, 212. My lord, celebrated judgment.
Yes.
We read a few paragraphs on it. I'm relying on my lord 24, 32, 33, 35, and 36. Paragraph 24 first, my lord, at page 237.
Yes.
The state cannot be attributed the split personality of Dr. Jekyll and Mr. Hyde in a contractual field so as to impress on it all the characteristics of a state as a threshold while making a contract requiring it to fulfill the obligation of Article 14 of the Constitution and thereafter permitting it to cast off its garb of state to adorn the new robe of a private body during the subsistence of the contract, enabling it to act arbitrarily, subject only to contractual obligations and remedies flowing from it. It is really the nature of its personality as state which is significant and must characterize all actions in whatever field and not the nature of function, contractual or otherwise, which is decisive of the nature of scrutiny permitted for examining the validity of its act. The requirement of Article 14 being duty to act fairly, justly, and reasonably, my lord. There is nothing which militates against the concept or requirement state always to act, even in contractual matters. They will have to act fairly, my lord. Then, my lord will kindly have paragraph 33. At page 242.
Yes.
No doubt, it is true as indicated by us earlier that there is a presumption of validity of a state action and the burden is on the person who alleges violation of Article 14 to prove the assertion. However, where no plausible reason or principle is indicated nor is it discernible and the impugn action therefore appears to be expressly arbitrary, the initial burden of proof the arbitrator is discharged, shifting the onus on the state to justify its action as fair and reasonable. In my humble submission manner, I have shown there is absolutely no reason that document has not become invalid. In my humble submission, I have been able to demonstrate my lord, there has been arbitrary action of power, my lord. So at this stage, my lord, I am praying for notice. I pray for an interim protection that let there be no fresh draw of lots. Will serve them justice if your lordship allows, so that the matter can be traced out as early as possible. They have no representation, they don't have a standing.
By Mr. D. Bangin, the counsel for the petition. This is an issue under Article 226 of Constitution of India, praying for a writ in nature of certiorari and or mandamus or any other writ inappropriate, any other appropriate writ, orders, less orders, or directions of like nature. It is submitted by Mr. Like nature first. Against the order was on your rejection order was on
It's a communication dated 18/4/2024.
against the telling the validity of the impugn letter / order dated 18/4/2024. Sent by 18/4/2024, sent by Bharat Petroleum Corporation Limited, informing the present petitioner that his candidature has been rejected on the ground that the land documents submitted by the petitioner are not valid, are not valid for considering the offered land under Group 1 as notarized lease deed cannot be considered under Group 1. post. Um, issue notice to the respondent to registered AD and SGL process, and also considering the prayer of the land council for the petitioner, the notice may be also issued through dusty motu. Next paragraph. The learned council, Mr. Pangi, further submitted that the present petitioner was selected. He was selected, na, earlier?
Yes, my lord.
In which page?
My lord, just a moment. At page 109.
That the petitioner,
28
submitted that
December.
the petitioner was one of the applicant. 103.
109, my lord. Dated 28th of December. Annexure 5.
Whereby the submitted that the present petitioner was selected as a retail outlet dealership under the petroleum. And after draws of lots of selection, and accordingly he was asked to file the required land documents, etc. Accepted. In pursuant to that, the present petitioner has submitted all his land documents, including the lease deed, of the land, which was it was leased under the clauses there that it should be beyond 19 years or
Yes.
so you are
Old one was for
that
20
criteria is fulfilled.
Yes, 20 years.
Listed the land which were under their which was under their lease for since 20 years. However, his candidature was rejected only on the ground that the said lease agreement was notarized and not registered.
It was registered, my lord.
Notarized. They had rejected. It was not. It
They-
was
No,
only notarized.
they do not say it was not registered.
Okay.
They say notarized cannot be.
Rejected as his deed was notarized, and it is the ground of his rejection that the notarized document cannot be accepted as a valid land document. But the concerned authority has failed to see that of the said lease agreement / the land document was not only notarized, but it was registered under the sub-register East Siang District, Pasigat, AP. But without considering all these aspects of the case, merely on the said ground, his candidature was rejected by the concerned authority. He further submitted that it was not drawn till now again.
No.
Not yet.
No. But they're taking so much time, my lord. December draw lots, documents submitted in January 7th. Only now they have rejected. They have not doing it. We made a categorical
No,
mistake.
after rejection of
No,
your,
no.
they have not.
No.
Further, he submitted that till now, the withdrawal of lots of selection of retail outlet dealership in respect of Inverter Komalibo, in respect of from Cebu Parong Bridge to Ranaghat Police Check Gate on NH 515. You can see this from page 23. Is not yet conducted by the concerned authority, and accordingly he paid that paid as an interim to stay any further proceeding to be conducted for redraw of lots for selection of retail outlet dealership by the concerned authority. It is submitted by Mr. Pangi that his prayer for his candidature was rejected. On which date you are getting the information for your rejection of candidature?
Madam.
Your candidature was rejected on which date?
18/4.
18/4 of this month.
Yes, April, ma'am.
No, 18/4/2024, sorry,
Yes,
this
yes.
year. Submitted that his candidature was rejected on 18/4/2024. But thereafter, they have not started any proceeding for retrial of the lots of selection of the retail. Selection of the retail outlet dealership. The next para. Considering the in the post of next para, the learned counsel, Mr. D. Pangi, further relied on two decisions of the Apex Court reported by 1991, 3 SCC, page 273, wherein it has been expressed the view that the candidature of a petitioner cannot be rejected only for technical irregularity for little or no significance. And further, he also relied another decision of the Apex Court reported in 1991, 1 SCC, page 212. Expert, considering the entire submission made by the learned counsel for the petition and other aspects of the matter, as an interim, the procedure of redraw of lot selection retail outlet dealership by the concerned authority is hereby states that's suspended. If it till next date it will be suspended, let them hear first. It will be, interim order is for next date only. Thereafter we'll hear.
My lord, will pass an interim order restraining them. On the next day, since they have not been represented, my lord, they will be at the liberty to file any application for vacation of the same. That is how it is done now. Because prima facie, I have been able to show, my lord. Because by the next time, if there is a selection, my lord, my petition becomes important. My lord may give them the liberty to file any application for vacation.
They will file the yes. They go to the list after 4 weeks. The state proceeding corridor till disposal corridor. Till pending disposal of the present petition, new petition. Okay. It will be till disposal of the present petition. If they file anything, it is at the other party. Okay, then. Your interim prayer is allowed.
My lord. Obliged.
Yeah.
Yes.
Item number 3, my lord, this private respondent number 6, my lord, has requested me for adjournment of the matter. Otherwise, it is a very simple case, my lord. Without issuing prior notice, my lord, I have been issued with eviction order. It is a settled law, my lord. This matter may be fixed on this 10th on Monday, my lord. 10th. 10/6, my lord. Monday. Private respondent has requested, he has some personal difficulty.
Who is appealing for private respondent?
Oh, Pada.
He's not here now. Monday, I cannot see, is there any list is already on? Monday, you party. Monday, they say, guys. Huh?
Monday, my lord.
Monday.
Very simple
List
case.
accordingly on Monday.
One line.
Or simple order for list on Monday. 10/6.
Months. Obliged.
Wait, please. I thought Mr. Perme, appearing on behalf of the power department, he wanted to file an affidavit on the last application. I don't see him here.
Forme was supposed to file.
Yes, not the government, the power department, respondent number, my lord. The government has already filed. They are with the petitioner, in fact.
Standing council department.
Power department, executive engineer, my lord, respondent number 7.
He is for respondent number 7.
Yes, power department. There is an affidavit, my lord, that supports the case of the petitioner. So in that respect, he wanted to file an affidavit on the last.
Have you filed?
Lordship is in code number 2.
Huh?
Mr. Elfam is in code number 2.
I'm not listening. What
Lordship, but Mr. L. Permis is coming now.
is coming?
Yes.
Wait for some time. Okay. Okay. But otherwise from the affidavit reply not yet by who is here.
Yes. In fact, there is an observation by this court whether the affidavit will have any meaning. or
Have you filed the affidavit? Not yet.
File we have filed. I filed that on 9/1/2024.
Affidavit.
It's in a
9/1.
9/1. To the affidavit filed by the respondent number 1, 2, and 3. It's affidavit by respondent 1, 2, 3.
Oh, I'm sorry, man. I
Hold
I have just seen it. But anyways, some other deadline, I will argue, man.
No. Then why it is the order was passed? It was passed that as per order dated 15/11/2023, you were asked to file.
In term of that, I have filed on 9/11 on 9/1/2024. In term of that order, I have filed.
This note is not there.
But I have got it.
9/1 office note is here?
Yes, it's not filled up, my lord. I have an affidavit, my lord, but
No, definitely.
I don't know whether it is in your, my lord's copy report.
No, in our office note,
But
it's not reflected. That's
It's
what
not
I'm
filed.
saying. You have filed your affidavit on 9/1/2024.
Then I need to cross check that.
It's not here. That's what I'm searching for, in fact. Anyway, as per your information, or as per you have filed on 9/1.
Or if not by file, I will file my letter. I need to cross check.
And state has already filed.
yes,
So otherwise it's ready then.
otherwise, it's-
Heard Mr. Deepanging, the learned counsel for the petition. And also heard MS so-and-so, the learned government advocate for the respondent number 1, 2, and 3. But first of all, it is submitted by Mr. L. Permit that in person to order dated 5/11/2023. The respondent number 7 has already filed his affidavit in opposition on 9/1/2024. Listed matter accordingly. After 2 weeks, will do.
Madam. Okay.
Both the matters I have found that Mr. S. Mao is there.
Yes, your lordship. He's out of station.
He is not out of station.
Yes. So your lordship, in this matter, all the pleadings have been done. So kindly this matter may be fixed for hearing.
Otherwise, from your side, it has already been filed.
Yes,
affidavit in
Your Lordship,
opposition. Is ready.
Yes, we have filed.
And then why it is listed in the admission column? Is there any order of admission? No. Can it be admitted then? It may be listed on final profile. Yes. You are Miss
T. Choten.
D. Loda. So and so. And also Harsh NS so and so Dilanet government advocate appearing. You are first, you are SC RD or?
Yes, sir. Yeah.
And who is appearing for land management?
Dugmar Kamdogista, standing counsel.
Standing counsel. And also heard Mr. B. Mitra, the learned standing counsel for RD. Is submitted. And then SC land management, they have also filed their affidavit in opposition.
They have not filed, Your
They
Lordship.
have not filed.
No.
Then what will you say? They have not filed it. RD, they have already filed.
3 and 4 state has also filed.
Who is 4 and 5 in fact?
4 and 5 is RD.
5 is RD. No. Subsequently, the three, 5 and 6 were, so they are the RD.
Yes.
So for 5 and 6, we have already appeared.
Yes.
And
For 3 and 4, I'm appearing, Your Lordship, we have filed.
3 and 4. I don't know whether 1 and 2 has already filed. No, note is not clear, in fact, that's why I'm.
No, I guess.
3 and 4 and 5. For 1 and 2, not filed, I think. No? Have you received any copy such?
No, Your
Opposition copy of? 2 and 3 is there. No.
3 and 4.
Yes, 3 and 4. And the Rejoinder. 4 and 5. 1 and 2 is not here. And he is not present today. Let us give we'll give him one more chance for land management. Her Suresh Dylan, and also her Mr. P. Picha, Dylan Council appearing, Plan Standing Council for the RD. It is submitted by the MS so Dylan Government Advocate as well as the Standing Council for the RD that they have already filed their affidavit in opposition on behalf of the respondent number 1. You are 3, 4, 4, 5 and 6. However, from the office note as well as from the record, it is seen that the Standing Council, the lands management, that is the respondent number 1 and 2, has not filed their affidavit in opposition till date. And hence I find that one more chance may be given to the respondent number 1 and 2 to file their affidavit in opposition, if any. List for the matters accordingly up to 2 weeks.
Your Lordship, there is an interim order that may be
Interim
taken.
order was there. In both the matters, interim order was there or in 1 or in 4 only. In 4, in 5 too, there are interim.
Yes, Your Lordship.
In 6, I don't know. 5 to interim be continued till next date of listing. And 6, let us see.
In 6 also, Your Lordship, there was interim.
6 also, I think.
Yes, sir.
6 also. Oh.
Bless you.
Yes, item number 8.
Submit correct. May Your Lordship, in this matter, we have received the parawise comment, so at least 4 weeks time may be needed, Your Lordship, for filing our counter
Otherwise,
affidavit.
parawise comment you have already received.
Yes, Your Lordship.
Your Lordship, they have got a last chance on 29/11/2023, Your Lordship, as per the order. In
But
an
your order dated which?
29/11/2023.
29/11.
Yes, 2023. On that day also, they have submitted this, that they have already received the parawise instruction from the department, and they need some more time to
Yes.
finalize it.
It was the last chance.
Yes, Your Lordship.
But that time, Your Lordship, we need some clearance, that's why, Your Lordship. But
Now it's 2024, June, Your Lordship.
Yes, you're rightly submitted.
some clarification was there, Your Lordship, so now we are going to, at least 4 weeks time, maybe give any, Your Lordship.
Your Lordship, kindly give them last chance, like short date, Your Lordship, not more than that.
We'll see.
Short date.
At least 4 weeks, Your Lordship. Needed, Your Lordship.
They have already received instruction in 2023, Your Lordship.
Actually, from department, there is to come from Bomdila, Your Lordship, that's why. At least 4 weeks, Your Lordship.
See, for department, it will take some time because
Yes,
you know,
Lordship.
private party and department is quite
Yes.
different now.
Yes, Your Lordship.
Style of working, style of submitting, all are different.
But Your Lordship, since 2023.
It is there.
Yes.
You are MS?
Jyoti Jongluju, J Jongluju.
Hard MS, J. They learned it. Counsel for the petition, I also heard MS, so the learning government advocate appearing on behalf of state respondents. It is submitted by MS Jyoti that as per order dated 29/11/2023, the state respondent was given last chance for filing their affidavit in opposition. Post of this context, MS so-and-so, the learning government advocate, has submitted that they received the prior voice comment earlier, but due to some but some clarification was needed, and hence the affidavit in opposition could not be filed by the state respondent. Accordingly, she submitted that 4 weeks time may be allowed to given to file their affidavit in opposition. Post MS Jyoti raised objection and submitted that short date may be given to the respondent side, responsive responder, as they have already given lots of opportunities to file their affidavit in opposition. Post. Next, considering this submission made by the learning counsel for so and so, the learning government advocate appearing on behalf of the state respondent is hereby asked to file their affidavit in opposition on or before the next date of listing. List accordingly. After 1 month exactly, we are listing it. And within that, you give it. Today is next to it will be vacation, na? Immediately after vacation, it will be the 15 or 16.
The 16, Your Lordship, not 16. Okay, 16, Your Lordship, Tuesday.
I'm fixing it a date, huh? List on 16/7/2023, enabling the state respondent to file their affidavit in opposition. However, it may be considered as a. However, the respondent is hereby asked to submit their affidavit in opposition without fail. In default, matter will be decided on hard accordingly. Okay.
Highly obliged,
Yes,
Your
Your
Lordship.
Lordship.
My lord, I'm on behalf of Ms. M. Karbak, my lord.
Huh?
M. Karbak.
Acha.
But she is not well, my lord. That's why. It may be listed, she is not well. It may be listed.
Karbak.
Yes, that may be listed after 3 weeks.
Mr. You, Mr.
Pitapo.
Pitapo, the counsel appearing on behalf of Mr. She MS.
Yes, she.
MS M. Karba, the counsel for the NPS counsel for the petition, and submitted date. Due to her ill health, she could not appear before the court and accordingly paid for an adjournment, to which the respondent raised no objection. So what kind of she is suffering from this? Can it be listed after 1 week or 2 weeks?
After 3 weeks, lordship.
After 3 weeks?
Yes, I don't know. A different problem.
Okay, it's after 3 weeks. Okay, well.
Pleasure.
So it is in order column, why?
Sorry. Well, the basic challenge in this read petition is the cause of action has occurred in Assam. The Arunachal Pradesh State Women Commission take cognizance of the offense committed in Assam. Number one, on territorial jurisdiction, and my lord is aware that in terms of section 177 of the CRPC itself speaks for number one. And number my lord, in CPC, section 6 says the pecuniary jurisdiction in the terms of the CPC. My lord. Now, here is a case, the cause of action, my lord, the petitioner is the husband, my lord.
Just a second. Otherwise, case is ready. Affidavit in opposition, you have filed already?
Yes, ma'am.
Both you?
Yes.
Oh, yes. Oh.
We can
Fine.
proceed, my lord. Yes.
Yes.
No, okay, that okay. Now, my lord, we'll see. I'll go ahead with the status for the timing, my lord. Now, my lord, the private petition number 3 is married to the private respondent number, private respondent number 3 in the year 2010. That is fact of the case, my lord, I am projecting now, as per Bengali customary, my lord, system and practice. And thereafter, the petitioner number 3 and the private respondent, they lived happily as a husband and wife in the village called my lord Baligaon. Baligaon, that is called POPS Bandardawa, district North Lakhimpur, Assam. Now, interestingly, my lord, the petitioner number 3, the husband of the private respondent number 3, works in the Arunachal Pradesh police, my lord. From there, he walks every day nearly 3 kilometers. That is police training center at Bandardawa. Walks there for the work, for the purpose. And then, my lord, what had happened? The private respondent number 3, after certain years, started torturing the 76 and 80 years old mother and father, my lord. Then there was a commotion between them. Their marriages were almost on the verge of collapsing, my lord. Then what had happened? A divorce suit was filed in the court of North Lakhimpur, my lord. So, my lord, the first opening submission that I made was that the cause of action has occurred in Assam, my lord. Therefore, it fortifies my argument that by filing a divorce suit in North Lakhimpur Session Court or the family court, my lord, itself fortifies my submission to an extent that yes, the cause of action as defined in the CPC in section 2 and section 177 of the CRPC stands firmly. So meaning thereby, any complaint which the private respondents have made before the State Women Commission is nothing but a vengeance, my lord, recourse of the law to harass the petitioner. Now, my lord, that is sum and substance of the case. So therefore, my lord, I seek the indulgence of my lord to the fact of the case, my lord, on the basis of the annexes, my lord. Now, my lord, will kindly come to paragraph, page 16, that is a copy of case status of the divorce suit in North Lakhimpur, my lord. Well, this is the case status, my lord. We'll see, my lord will understand. Now, my lord, page number 17 to 25. Well, 17/5/2019. Dated 17/5/2019 at page number 17 to 25. It is the complaint, a copy of the complaint petition filed by the private respondent number 3 before the Arunachal Pradesh State Women Commission.
This is before Arunachal State Commission.
Yeah, Women Commission. My lord, we'll surprised to see at later point of time, the Women Commission, my lord, being an advisory in nature by product of a statute, my lord, has become the adjudicatory body or per se recourse to the original jurisdiction of a criminal court, even to grant maintenance, my lord. This is something, my lord, very unfortunate. My lord, will see at page 17, my lord. There's a Gayatri Devi, my lord. Normally, I don't take the name of any woman, my lord.
7, 7,
Page 7, 117, my lord, 17.
okay, yes.
This is the complaint, my lord. My lord, fact already set out. My lord will come to page 22, the prayer person. The prayer as enunciated are direct aim, not direct principal PTC Bandardava to suspend constable so and so during pendency of an inquiry before your honorable court. Well, can these kind of hostile that should be sent, all that should always be sent, my lord. Number B, my lord, that the respondent husband and co-respondent, who are those co-respondent? The mother and the father, my lord, all mother and the fathers. Be ordered and decreed to pay to petitioner an exemplary damages for the reasons of his having committed adultery with petitioner's wife. Well, something, my lord. These are, see, my lord, kindly see. Direct respondent husband to be paid sum of rupees 30,000 as a monthly allowances to the petitioner till disposal of the case. My lord, in Katina of the judgment, Honorable Apex Court as well as our court have held that 25% of the total salary should be paid. Subject, if there is something like if she is not staying with me or for some reasons, my lord. Well, 30,000, a constable, my lord, hardly, what must be the salary? 50,000 rupees. There's an old mother and father, my lord, I have to maintain myself. My lord, kindly see D. Direct OCPS Bandardwa to register a case, my lord. If it is, say, my lord, the criminal law can be set into motion subject to filing of a complaint or the FIR, basing on the cognizable and non-cognizable offenses. If it is a cog offense, then immediately the police will swung into actions. What is mandated in 153, my lord. So these kind of, now see, my lord, E, directing appointing authority to terminate. Well, this is something, my lord. And then further be pleased to. Now, for this purpose, my lord, I was referring to, my lord, why this has happened, my lord. Now, my lord, then summon was issued, my lord. To all the respondent, we appeared. My lord, kindly come to page 27. That's typed copy, more legible, my lord. Now, my lord, one thing, my lord, will kindly mark in the SD portion, my lord. Procedurally, this is not correct, my lord. Name is so and so, is chairperson AP State Commission for Women. My lord, it is not. It is the member secretary, my lord. It is the member secretary, the chairperson by name cannot issue any summon, my lord. Very unfortunate, my lord. If the office procedure and propriety, say for example, we cannot write a letter directly to their lordships. We have to write through the registry. And registry is the one who will communicate with us. Similarly, the chairperson by name, he or she cannot do that. This is first mistake where my lord will see that how things are going wrong in the commission itself. My lord. Then my lord, kindly see content of this. The last paragraph of that order. If you fail to comply with this order without lawful excuses, you will be subject to the consequences of non-attendance laid down in Rule 12 of Order 16 of Code of Civil Procedure. Correct, my lord, the commission.
Where is the your notices are F page?
Yeah, my lord, page 26 is the original copy, 27 is typed copy, my lord. Page 27.
Page 26.
26 is the original copy, which is not legible. May I assist, my lord, to find out? Annexure 3 series. Page 26. 26. No, petition, page 26. यही है petition तो next page. Yes, madam, this is correct, madam, this is correct.
Yes. Okay.
This is how the things have happened, my lord. Now again this summon to the mother. Same thing, my lord. Now this is the elder sister who has been summoned as page 30. Is the elder sister who has been summoned as a witness, my lord.
Elder sister of,
But annexure 4, this is Assami Sorkari Lothai. Or Uttana something, it is there that I cannot pronounce properly. I know I can read and write. That is, my lord, I think that is to whom it may concern, I think, this word. This is for one purpose, my lord, I have relied annexure 4. Kindly come to paragraph 7 at page 9 of my read petition, Lord. For what purpose I have relied, Lord. Para 7. Page 9, Lord. That the petitioner begged to state that as per to whom it may concern certificate, it is to certified by the Gambura that the private respondent number 3 is a resident of village Bandardoa. Beligaon, POPS, PO Patali Pahal, PS Bihupuria, District North Lakhimpur, Assam, not from Arunachal Pradesh. Well, that is what I was stressing, that the entire cause of action has arisen in the state of Assam, whereby the State Commission for Women, the legs, possible for timing in the other matter. The State Arunachal Pradesh State Women Commission does not have a jurisdiction, my lord. So therefore, taking cognizance of a complaint and issuing summon itself is void ab initio, my lord. My lord, in Katina of judgment, when the root of the case, or per se, my lord, the foundation of the case is bad at the initial stage, then all the consequences that have happened go simultaneously, my lord. My lord will see this paragraph 8 also. My lord, I request my lord to kindly give some opportunity up to 11, para 11 to read out, my lord. These are crux of my case, my lord. That your lordship's humble petitioners state and submit that no cause of action has arisen within the state of Arunachal Pradesh, since the petitioners and private respondents are ordinary resident of Assam. My lord, other day I have given one judgment on the ordinary resident definitions, my lord. Therefore, registering and taking cognizance and further conducting the trials on the basis of complaint filed by a private respondent, a resident of Assam by the State Commission for Women is without jurisdiction, my lord. Therefore, same is liable to be quashed and set aside by this honorable court in exercise of its power under Article 226 of the Constitution, since the impugned action of the respondent number 2 is without jurisdiction and contravention to the objective of Arunachal Pradesh State Commission for Women Act 2002 to secure the end of this. Now the law here, paragraph 10, Miller, I have quoted the law. Paragraph 9, I have quoted the law. That it is needless to state it herein that the Honorable Supreme Court in the case of Bhavani Prasad Jaina versus Convener, Secretary, Orissa State Commission for Women and another, reported in 2010, 8 SSC in para 10, I have exerted below here, below the paragraph, has held that in other words, State Commission is broadly assigned to take up studies on issues of economic, educational, and healthcare that may help in overall development of the women of the state, gather statistics concerning offenses against women, proved into the complaints relating to atrocities on women, deprivation of their rights, in respect of minimum wages, basic health, maternity rights, etc. And upon ascertain main top facts, take up the matter with authority concerned for remedial measures, help women in a distress, a friend, philosopher, and guide in enforcement of their legal rights. However, no power or authority has been given to the State Commission to adjudicate or determine the rights of the party. Now, my lord, I have demonstrated in the prayer of the complaint letter seeking lot of reliefs. My lord. So these, to my understanding of the law, my lord, over the decades, the commission has violated its own jurisdictions. You do not have the power to do that. My lord. So, my lord, then there's another thing which they are asking for a grant of maintenance under 125. My lord, kindly see at paragraph 10, I have described it nicely, my lord, that it is respectfully submit that the maintenance allowances as paid by the respondent number 3 from Arunachal Pradesh State Women Commission for women is in contravention to section 125 of Criminal Procedure Code 1973, as power to grant maintenance allowances is vested solely in the hand of judicial magistrate first class. So that is a law, my lord, because that is a substantive and procedural law, and that under that the regular judicial magistrate exercises the power. As such, Arunachal Pradesh State Commission for Women has no power to take cognizance of complaint made by the private respondent number 3 and adjudicate and decides the rights of the parties, and therefore is completely illegal, arbitrary, erroneous, and same is not tenable in the eyes of law. Now that act, my lord, act I have annexed in Annexure 5, my lord, that particular, my lord, we will examine together, my lord. That it is respectfully submitted that the impugned action of Arunachal Pradesh State Commission for Women for taking cognizance of complaint filed by the private respondent is in violation of Section 2 of the Arunachal Pradesh State Commission for Women Act. My lord, can you see Section 2? Where is that? Volume 8. Old one. Page 109. Definition clause, my lord. 2. Commission means as it has no judicial risk can conduct for trial actions occurred outside the state. Commission means the Arunachal Pradesh State Commission constituted under Section 5. My lord, here I have referred to is that it is for the state of Arunachal. Yes, anything that had happened in the state of Arunachal Pradesh, this commission has every right and power to exercise the jurisdiction. Only for that purpose, my lord, I have relied this. Then, my lord, therefore, this prayer itself is one of the best prayer that I have expounded in this read petition, my lord. So as to demonstrate that without jurisdiction, you have taken up this one. Now, my lord, the rest, my lord, the normal submissions, my lord, I will not burden my lord also. So therefore, my lord, that prayer, certiorari should be issued to quash and set aside the entire proceeding, my lord. There is one thing, my lord, that I have made a prayer, and there was already a stay order, my lord. So what the other side says, my lord, because that particular annexures, my lord, which I have demonstrated, annexure 4, my lord, they are ordinary resident. Therefore, anything, my lord, this kind of law has to be laid down, because the commission keeps on floating the laws, taking the system procedure at their own whims and fancies. This should not be allowed, my lord, because we are in a democracy, my lord. In democracy, the rule of law must always be prevail. And rule of law, my lord, it talks about the procedures, my lord. It talks about the propriety, my lord. That is how one has to conduct himself in a social desirable way. is without prejudice and malice to the rights of other side, my lord. I conclude my argument to an extent that the entire action as initiated by respondent number 2 is without jurisdiction. Therefore, the entire proceedings should be interfered with by issuing the writ of certiorari and pass the proceedings.
My lord, I'm representing respondent number 2 and 3, my lord. Here,
2 and 3.
2 and 3, lordship.
But who is 2?
2 is the State Commission for Women.
Oh,
3 is the private respondent.
yes.
Yes.
Ah.
So, Malad, the basic argument that has been advanced by the petitioner is that, Malad, that the petitioner number 2, Malad, their main stress is that she is not from Arunachal Pradesh, but from Assam. That's the otherwise, Malad, if your lordship sees the petitioner number 3, Malad, he is working in the police department of Arunachal Pradesh under PTC, Police Training Center, Bandadeva, within the jurisdiction of Arunachal Pradesh. And they have annexed the I card also in the writ petition itself.
My lord, I am required in court number 2 also. My younger is there, and I think I will not make any rejoinder, my lord. On law and fact I have demonstrated.
First of all, Malad, regarding the jurisdiction, Malad, he is a constable working within the territorial jurisdiction of Arunachal Pradesh. It is government employee for Arunachal Pradesh. That they have annexed the I card also in the writ petition, that he is a police constable working under the police department of Arunachal Pradesh. That's number 1. Number 2, Malad, this writ petition is premature. Commission has the power. They don't say, but commission doesn't have the power. Commission has the power to, whenever there's a complaint regarding Malad, any Malad atrocities committed to a woman, Arunachal Women Commission has the power to inquire into the matter. And this is at the inquiry stage. No order has been passed, I said. If your lordship comes today, Malad, may kindly take up the affidavit filed by the respondent number 2, ma'am.
Yes.
Page 11, Malad, this is a complaint which my brother has already shown, Malad. This is the complaint filed by the respondent number 3 before the Women Commission. Malad, so many prayers have been made by the respondent 3 before the Women Commission, Malad. It is not that, Malad, all the prayers will be accepted. The duty of the Women Commission is to inquire into the matter and find the fact what's really happening within the parties, Malad. Then only Women Commission will pass an order, Malad. No order has been passed yet, Malad. Where the question of interfering at this inquiry stage. They also agree into the position that Women Commission has the power to inquire into the matter, and it has this jurisdiction to someone under the CPC. All the civil powers has been accorded to the Women Commission. And your lordship sees page 24 of this affidavit.
No, but if you're saying that it's still in the premature stage.
Yes, inquiries.
In that case, why notice was issued to them?
To find the fact, notice should be issued to them. Otherwise, how the Women Commission can determine what's the exact position between the parties, whether atrocities are being committed or not. In the statement itself, the petitioner husband admits that he has some extramarital affairs and all that. All those have been stated. We are not into that. Ultimately, the Women Commission has not passed any order as on date. If your lordship sees section 14 of the powers of the commission,
You annexed one.
Your lordship, just my brother has given that, my lord. We have also annexed here, man.
Yes.
It's no, page 44. Man.
Ah, yes.
Page 44. Your lordship got it.
Yes.
Yes. Now, my lord, powers, the commission shall, for the purpose of an inquiry under this act, man, have the same power as are vested in a civil code while trying a suit under Code of Civil Procedure Code 1908.
Page
section
44, your
44, lordship, yes.
in your affidavit.
Yes. Otherwise, the act is,
The act is there.
yeah, page 44, lordship, just, it's a bent,
Hmm? Ban portion, no?
no, yes,
This one,
yes.
49 in fact.
44, just before that, man, 44.
40.
I'm just, my lord, there's some, just check the lordship. Here. Just second. Yes. Yes. I'm sorry, my lord, there's some pagination problem, it seems, my lord.
So it
Yes.
starts from 49, I think, na?
My lord,
Page number 49.
no, it's a
53.
53, lord. Section 14, man. The commission shall, for the purpose of inquiry under this act, have the same powers as are vested in the civil code, trying suit under Civil Procedure Code 1908 in respect of the following matters: summoning, my lord, and enforcing attendance of any witness and examining him or oath, requiring the discovery and production of any documents, receiving evidence on affidavits, requisitioning any public records or copy thereof from any public office, issuing commission summon for the examination of witnesses. Any proceeding, proceeding before the commission shall be deemed to be a judicial proceeding within the meaning of section 193 and 228 of the Indian Penal Code, and the commission shall be deemed to be a court of purpose of section 195 Code of Criminal Procedure Code 1973. If your lordship sees next page 54, functions of the commission. The commission shall perform all of the following functions, namely, inquire into any unfair practice. One, inquire into any unfair practice, take decision thereon to recommend the government and actions taken to be taken in that matter. Cause investigation to be made by the member secretary on issues or importance concerning women or issues concerning the unfair practice, and to report thereon to the government in the corrective measures to be taken, women related issues. Well, these are the things, Malar. Unfair, wherever, now, lordship, if you comes to the P, Malar, page 55. I'm, Malar, functions A and B, Malar.
that we are concerning manner, A and B, it has power, and P manner. Now P manner. Whole family court to dispose of cases related to unpractices against women. It is also a family court manner. And 16 manner. Inquiry into unfair practices. Your Lordship was 16 months. The Commission shall inquire into any unfair practices in receiving a written complaint from any woman alleging that she has been subjected to any unfair practice or on similar complaint from any registered reputed women organizations of individual on its own knowledge or information or request from the government matter. These are the powers of the Women Commission. Now, therefore, when there's a Lordship has seen a complaint has been received, my lord, by the Commission, my lord, whether Commission will still sit still and not do anything, my lord. When the respondent, he is a police constable working under the Arunachal government. So definitely, the Commission has taken a stance that is necessary to take not action matter, inquire into the matter, and whatever matter, if it once it may dismiss the complaint also, matter. We don't know the future of this case as on date, matter. It may dismiss the case, it may make some recommendation, it may try to make some reconciliation as a family court, matter. The Commission may do anything, matter, but it's too premature at this stage, matter, for the petitioner to approach this honorable court. Now, Lordship, now kindly take up the affidavit of respondent number 3. Lordship, respondent number 3, madam. I'll not take much time, madam. Just show 2-3 pages of annexure, madam.
Yes.
Now, Lordship, kindly turn page 10, Lordship. Page 10, Lordship. This is the Aadhaar card of the respondent number 3, Lordship. Now, kindly see Gayatri Das, madam, right side, madam, address, madam. Wife of Siddhartha Shankar Dev, near PTC Bandardeva, PTC Bandardeva, Papumpare, Bandardeva, Arunachal Pradesh. This is her address. Now, page 11, Lordship. Though their address would be different. Now, this is ration card. Kindly see this government of Arunachal Pradesh ration card issued to her, madam. District Papumpare, madam. Circle Bandardeva. General House, madam, Gayatri this. Madam, full address PTC Bandardeva. Now, Lordship, page 13, 12, my lord. 12 is it's not so visible. Typed copy is page 13, Lordship. Now, there were disputes between the husband because of the extramarital affairs, man. Now, kindly see the undertaking given by the petitioner, man, before them, whom he has, the undertaking where he has given. Now, kind of page 13, Lordship. As Sri Siddhartha Deva, son of C.R. Dev of PTC Bandardeva, do you hereby promise before the OCPS Bandardeva with correct state of mind, without any pressure or condition that I will not continue any physical relation, but I'm not naming her, madam, of village Gogamang, such and such, from today onwards, maintain a cordial relation with my wife. Further, I will not carry any nuisance at home in this area. Failing to do so, I shall be liable as a provisions of law. This is before the OCPS Naharlagan Bandardeva, within the jurisdiction of Arunachal Pradesh. When the petitioner, Malad, he's working within the territorial jurisdiction of Arunachal Pradesh, and the wife is under his care and Malad within the jurisdiction of Arunachal Pradesh. Arunachal Pradesh Women Commission has the jurisdiction to inquire into the matter. Malad. Therefore, unless any order is passed by the State Commissioner for Women of Arunachal Pradesh, Malad, this writ petition is premature. Malad. No case has been made out as such. Prima facie case for interference. Therefore, I pray, Malad, this writ petition may be dismissed, Malad. Rest, otherwise, Malad, the presumption that such and such prayers have been made, such a Malad, a complainant will make Malad numerous, definitely different kind of prayers, Malad. It is not necessary that Women Commission will consider all those prayers, Malad. This is simply an apprehension, Malad. On apprehension, writ petition, it's not maintainable. Unless an order has been passed by the State Women Commission. He can approach this court after the Women Commission passes an order. If he's agreed, definitely he can approach this court. But this writ petition is premature. That's all.
Yes, you are for one, please for one. Want to submit anything else? It's okay. Ajay, to step up any. Pass the order, matter will be disposed of today.
Malad?
Matter will be disposed of today.
Obligation. Yes.
You
Malad, in this matter, Malad, we were supposed to file a rejoinder, Malad. We could not, Malad. Therefore, 2 weeks time may be given, Malad.
will do it.
Our next item. Please,
Oh.
14.
I thought you were again
No.
going to submit the other.
No, no.
Anyway, 14.
Yes, 2 weeks time may be given to file rejoinder.
Okay.
No, he won't mind, my lord.
He won't mind.
No, they wouldn't mind.
Best made by the council for the petition, Mr. Vito. Bring some more time to find their affidavit in rejoinder. No, and the council, party council for this and so, bring for some more time to find this in their conference. The learned Standing counsel, land department, the Nambu, and the leaders, government advocate, state government, state, government advocate, raise no objection. You're for the land management.
Yes, my lord.
And you're for?
I'm for the Union of India, correspondent number 2.
Respondent number two.
Yeah.
And you're for? Three. Negative. Raise no objection. Mr. Kaur, how many time you?
2 weeks, my lord.
2 weeks.
Yes.
Check on it. And applicant petition to file their affidavit in reply.
Much obliged.
Item number 15.
Yeah, my lord.
Yes.
Private respondents 3 and 4 have filed their affidavit. Also. However, state respondent, they are yet to file their affidavit.
Your lordship, we need some more time to file our affidavit.
You're for private respondent.
No, your lordship, state respondent.
State.
Yes.
Private respondents have already filed.
Private respondent has already filed.
Yes, sir.
So you're for 1 and?
2.
1 and 2.
Yes, your lordship.
5, 3 and 4 are the private.
Yes.
I'm for respondent number 3.
You have
I've
already
already
filed. 4 also already filed.
Already filed.
So how many weeks you need?
3 weeks, your lordship.
3 weeks. Okay, Boyaniki. Mr. Taylor. Oh, no, sorry. Yes. No. For the petitioner, who is it?
I'm for the petition.
The petitioner and also her. Mr. You are for Ananju is for 3.
I'm for respondent number 3.
3 and you are for Mr. You are Mr. Elnara for 4 and also here the implemented bit for the appearing of behalf of respondent number 1 and 2, Mr. So and so. Poster. It is submitted submitted to the respondent number 3 and 4. The private respondents had already filed their affidavit in opposition. However, Mr. So and so, the learning government advocate appearing on behalf of respondent number 1 and 2, pray some more time to file their affidavit in opposition. Prayer allowed. This the matter accordingly after 3 weeks, enabling the government advocate, this government state respondent to file their affidavit in opposition. So you are getting 3 weeks time.
Lordship, interim order passed earlier, maybe continue.
If an order was there?
Yes, Lordship.
If an order passed earlier, we shall continue till next day. Okay.
Highly obliged.
Item number 17.
Malay, this case, bank have already.
On 5th of March, there is an order passed by this Honorable Court. Let them comply that order at least. 5th of March.
On 5th of March?
Yeah.
So, what is it now? Earlier was also, it was a direction of on 28/1/2022 also, no? Earlier one direction was also there by this court on 28/1.
The 28/1 the appeal was dismissed. The orders have to be implemented. Against that, they have filed an appeal. On 28/1, the order appeal was dismissed. So the contempt is continuing.
Okay. Achha.
Because against the order of the writ court, they have filed a writ appeal. The writ appeal was dismissed on 28th of January. That is the.
So what are the instructions?
They are going to
No,
comply, but there
they
will be
are going
some
to comply.
specific dates.
Process is on to comply the order.
But there's a time-bound order. It should be complied within a limited time. Order was passed in.
Going to comply otherwise.
No, they have not complied. They
No,
are
no, 11
saying we are in the process of complying. But how much time? Let there be a definite time because it order was passed in 2022. Now in 24. That's a time bound order. Within 3 months they have to comply the order.
On 24/4, they have already intimate to the petitioner.
It is on record. And the next date I filed the communication filed by issued by the bank. On the next date I filed on the 16th March, I filed that document also, but let there be a definite time so that they will comply the order, because petitioner is very old and is on the last page of his life. Let them comply the order in a limited time.
They are going to comply. They say already intimated to the petitioner, they are going to comply and the process of
Not
comply.
merely intimating we are going to comply, but they are not complying since last 2 years. It's a time-bound order.
No, these are, it's okay, you have initiated the process.
Yes.
But do you have any other action that those were already complied with? Otherwise, we may list the matter on the next week.
Yes, next
It will
week.
be difficult on my part. or-
Can it be July, sometime in July, because I have some.
No. By the time if they have already complied with, then they may take instructions and furnish to us the
So
report.
my instruction is that a bank is taking steps because they have to take permission and all these things. That is how I.
No. As per you, as per them, the
There,
communication.
no, I
was
admit,
made.
I
They
do
already
admit that they are
initiated
in
the
the process of, they're in the process.
Initiated the process and all. So, but initiating process and whether the compliance is different thing. So
Yes.
that's what I'm saying, that if they have any instruction from the authority concerned that had already been complied with, so we can list the matter on the next week.
Next, I may be permitted to appear through VC because I am coming from outside. I can appear through VC because he is to file an affidavit to the action with the part.
Otherwise, as per your instruction, it has already been complied with or still in the process.
No,
of
they are
compliance?
taking
not
step to comply. In the process,
In the process.
as per this letter.
Then so it will be again.
My lord, the
When will be your
difficulty
convenient
is,
date? Your convenient date will be?
Well, I think first week of July because let
First
the
week of July, I will be not here because.
so
it will
next
be
week,
vacation.
let it come next week. I will appear through VC only if it lets it for me.
Yes, you can, by that time you can take instructions.
Yes.
Or you have need 2 weeks time. Just tell us because we need the compliance.
yes,
Now, the process initiation is different thing. If it is already been complied with, it's very nice.
No, not compliant with. Right?
That's what they.
Yeah. I will
Take the instructions. So if, can it be fixed on the next week?
next week on,
Next week, or you can say by the end of June?
yes, by the end of June.
By the end of June? That
Yes.
will be a fixed date?
Yes, sir.
Say 25th or 26th of June or something?
28 is working day.
2020?
28.
Yes.
Instead of 20th, people also can put it for 4th of July so that I can.
4th of July will not, court is not there.
Oh, okay. So like
Vacation.
then,
That's
Vacation, yes.
So let it be on 28th only, but through VC you were at it.
oh yeah.
And if they have the instructions there regarding the compliance, then it's okay, we can pass over.
Yeah. If order is compliant, then I don't have any
Yes, yes.
submissions to make.
I heard you are Mr. G.
G board.
G4, the Departmental counsel for the petition. You also heard Mr. G. Tara for the respondent, and it is submitted by Mr. Tara that they have already the process has already been initiated to comply with the order. However, he has no proper instruction as to whether that has already been complied with, and accordingly, paid to take instructions from the authority concerned, and hence, and let the matter be listed on 28/6/2024, enabling the state respondent to take proper instructions from the concerned authority as to whether the order has already complied with or not. Inside.
28th.
Yes.
Yeah. I'll appear through. I may permitted to appear to VC only.
Pardon?
I may permit to appear to VC only.
You made a prayer, it
Yeah,
will be considered.
Oh.
Item number 8.
Well, Lordship.
Yes.
Lordship, respondent number 3 yet to file a counter affidavit.
Respondent number 3.
and respondent number 4 yet to appear before the court, may I allow to take press step again
Service
respondent?
is not yet completed in respondent number 4.
Yes, my lord.
So you're for respondent number?
One.
Your state respondent, no?
Yes.
And who is yet to file their affidavit in position?
Yes, my lord.
Who is not yet filed their affidavit?
Three.
Three.
Respondent 3.
The private respondent.
Yes.
No, my
No,
lord.
no, my lord.
Huh?
Deputy Director,
UD.
Oh, sorry, 3, deputy director. Okay.
Yes, ma'am.
And 4 is not yet served.
Not so.
1 has already filed your affidavit.
Yes, ma'am. May I submit, my lordship, 2 and 3 will go with my affidavit of demand. Because Secretary UD, they are same department. Chief Engineer, UD department, Deputy Director.
Okay, then you can represent 1, 2, and 3 only. Okay.
There is a standing counsel, but he's not present here.
Otherwise, do you have any instruction that they are also going to follow, rely on your affidavit? in
No,
opposition?
no, they are not present. Otherwise, our affidavit will be same, reply will be same.
And that's what I'm asking, affidavit will be same. Do you have any instruction from the standing council that? So can we pass the order in that regard that you are saying your submission can be recorded?
No, my lordship, it's okay. Let them prepare, my lordship.
How do you, Mr.
M. Lago.
M?
Lago.
To silent. Had Mr. So-and-so. Learned counsel for the petition, also had MS. Yes, Sangeeta. A1, they learned. Government advocate representing the respondent number 1. You're for, then 2 had already filed their affidavit. No, 2 and
It should
3
be
had not-
actually 1, my lordship. By mistake, we have filed on behalf of 2.
You're
Actually,
for
we,
1.
yeah, we have
1.
filed.
1 and the 1, so-and-so. It is submitted by Mr. So-and-so, the learned counsel for the petition that 2, respondent number 2 and 3 get to file their affidavit in opposition. And the notice is not yet served on respondent number 4. So you want to await for the steps or you want to take fresh steps on respondent number 4?
Lordship, I will
It was
take press
still
step.
awaited. You take
Oh,
fresh steps because
mm.
it is awaited since 2023 itself.
Yes, my lord. I will take press step.
From the office note, it is seen that the service is awaited for respondent number 4 since 2023, and accordingly, the petitioner is hereby asked to take fresh steps on respondent number 4 to register AD and as usual process. And the respondent number 2 and 3 is hereby asked to file their affidavit in opposition, if any. List the matter accordingly after 4 weeks, it will list it. Just after 4 weeks. You take steps.
Yes, ma'am.
Item 119.
Your first state respondent.
Yes, we have filed the affidavit.
You have filed your affidavit. Rejoinder affidavit, they are supposed to file their rejoinder in
Yes.
It's not yet filed. Not yet filed. None appears on call for the petitioner side. However, had Mr. Wango, the learned advocate appearing, learned government advocate appearing on behalf of the state respondent. It is submitted by her that the state respondent has already filed their affidavit in opposition. However, from the office note, it is seen that the petitioner has not yet filed their affidavit, rejoinder affidavit. Rejoinder affidavit. List the matter accordingly after 2 weeks. We're listing it after 2 weeks. This is over. Oh, I listed matter.
Item number 25.
May I please, my lord, this matter is regarding transfer and posting order, my lord. And I have
Transfer
been-
order.
Transfer order, my lord, yes. So, my lord, I have been transferred within 1 year, my lord. Without completing the 3 years tenure, my lord. As per guidelines, one has to be transferred after 3 years, my lord. May I take my lord to the phase 21? Is my last transfer order. It was in 8/5/2023. It was my last transfer order, my lord. My name appeared at
Your
serial number.
last transfer order was on 8/5.
Yes, 8/5/2023. Then my lord, impugned transfer order is at phase 22. My name is appeared.
The respondent is Arunachal Pradesh Rural Bank.
Yes, Rural Bank.
Yes,
So
ma'am.
it is the one of the home under Regional Rural Bank Act 1976. Madam. So I am unable to read jurisdiction. Madam. So page 21 is the last transfer order. My name appeared at serial number 1. I have been transferred from Nahalagan branch to head office, head office. It is also in Nahalagan. Then my lord, this impugned transfer order is page 22, my lord. Next page, my lord. Common transfer order, my lord. 35 officers have been transferred to different region, my lord. Then my lord, turn to the page 23 is the relevant, my lord. Page 23, my lord.
The common transfer order was on 31st of May 2024.
24, yes, my lord. That's I've hardly completed 11 months. Then my lord, page 23, my name appeared serial number 4, my lord.
Serial number 4.
Yes, ma'am. And I've been transferred from head office to Basar, my lord. Head office to Basar, my lord. And in my place, my lord, serial number 20, my lord, private respondent number 3, my lord. Serial number 20, he has been brought from Basar to head office, my lord, in my place, my lord. Well, as per guidelines, I'll take my lord to the guidelines first. Policy. They have their own policy, my page 27, my lord. 27, my lord. Arunachal Pradesh Rural Bank Transfer Policy, madam, 2019. So I'll take relevant portion, my lord. My lord may come to the phase 34, my lord.
34.
34, yes, madam. Norms for transfer of officer group A, my lord. 34, my lord. My lord. My lord will find it the 4, my lord. Serial number 4, my lord. All the officer should normally be transferred every 3 years, my lord. And one more, my lord, may come down to the serial 11, my lord. No, 11, my lord. After posting for 2 tenure in one region, that is for 6 years, officer will be transferred to other regions. Because in Nahalagan, we have many branches, my lord. Itanagar also one branch is there, Nahalagan also branch.
In the last transfer order, you were transferred from Naharlagun branch to head office.
Yeah, head office, my lord.
Head office. So it is within Naharlagun.
Within-
Prior to that, where you were posted there?
Right, another region, Mariam. It is in Mariam, my lord.
It is under Naharlagun only.
Not under Nahalagan. It's another region, my lord. Different region, my lord. Nahalagan, different district, my lord. From that,
From other district, you were brought to
Nahalagan. Nahalagan, then again I transferred to Itanagar. Again, I brought back to the head office Nahalagan, and then now Basar. That has happened within 3 years, my lord, within 4 years, my lord. So as per these guidelines, in region I have to spend 2 tenure, 6 years. But without following this, my lord, guidelines, they have brought back the private respondent. Earlier, previous place of posting of the private respondent is at Nahalagan head office, my lord. As per the guidelines, before expiration of the 6 years, the officer cannot be brought back to the previous office, my lord. That is that my lord will find at phase same guidelines, my lord. Page 33, my lord. Page 33. 3, 4, 5, 6, 7. Page 33, my lord. And page 33, 1, 2, 3, 4, 5, 6, 7 column, my lord. My lord, the officer employee should. Officer, it is the second paragraph, my lord. The officer employee should not be posted in the same branch within a period of 6 years. Even after 6 years, she should not be posted in the same capacity at the branch where she worked previously, subject to the operational and administrative feasibilities. So, my lord, to substitute this, my lord, last posting order of the private respondent, my lord. I'll take my lord to the last posting order of the private respondent is at page 36, my lord. 36, my lord. It has been decided to transfer you from, that is private respondent 3, my lord, you from head office, that is Nalaga, and to the post at Basar. Now he is at Basar, now he is again brought back to here. This was at on 9/9/2022. So 6 years has not expired yet, my lord. So, my lord, therefore at this stage, it previously appeared that they had not followed their own guidelines, my lord. So at this stage, my lord, the operation of this imping order be suspended and notice may be issued to the respondent, my lord. Interim prayer at page 16, I have interim
Page?
16, my lord. Interim prayer, my lord. Annexure 4 and 5 is to be suspended, my lord. 4 is the interim transfer order, and 5 is the sought to be released on 11th, on this 11th, and private respondent is to join on 7th, tomorrow, my lord. So therefore, 4 and 5, in respect of private respondent, there are 35, my lord, officially there, in respect of private respondent and petitioner, my lord, that is to be suspended, my lord, till reasonable date.
So private respondent also, you are saying that his transfer should be stayed.
Yes, because he is brought in my place, my lord, by this transfer order, my lord. So in respect of private respondent and petitioner is to be stayed, my lord.
Let's see. Pass the order.
Obliged.
Certain.